Hey folks, good afternoon. I am Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years bringing federal lawsuits to enforce the USCIS Form I-864. I represent green cards who are the plaintiffs in these matters. Well, we recently had a first-of-a-kind decision in one of these cases, and a federal judge ordered an Affidavit of Support sponsor to be jailed, put into federal confinement until he decides to comply with his obligation under the Affidavit of Support. To my knowledge, that's the first time that's happened in one of these pieces of litigation. So let me kind of unpack how this happens in one of these cases and what it means for future cases. Generally, the government plays no role whatsoever in enforcing the Affidavit of Support. This contract is between the Affidavit of Support sponsor and the United States government. There's a federal regulation behind it. There's a statute behind it. And you might think that if the sponsor violates his financial obligation to the green card holder, that obligation is to provide support needed to maintain her at 125% of the poverty guideline. You might think that if the sponsor violated his obligation, the government would step in and make that sponsor comply with the obligation. But in fact, that doesn't happen. And indeed, there is nothing in the federal statute that even gives authority to the government to enforce the Affidavit of Support. This is a common misperception. The government is a party to the contract, but they do not play a role in enforcing it. Instead, the only person with authority to enforce the Affidavit of Support is the green card holder herself. So when we go into federal court and we enforce the Affidavit of Support for our clients, that is the way that the Affidavit of Support obligation is made real. Absent a private lawsuit by the green card holder, there's nobody else who's going to step in and make sure that she gets the support she wants. So private lawsuit, there's no government involvement. How do you get an order throwing a sponsor in jail? Well, in federal court, you can seek something called a preliminary injunction. Basically, you can think of this as a way in the Affidavit of Support context of forcing the defendant to comply immediately with the Affidavit of Support obligation. So federal litigation lasts a long time. Usually you don't get the relief you are seeking until the end of litigation, right? That's what will come ultimately in the form of a judgment or settlement if that's the outcome of the case. But that can be months or even years in the making. That's not good enough for some of our clients. Remember that by definition, to have a claim under the Affidavit of Support, your income has to be under 125% of the poverty guideline. So we are talking about low-income, vulnerable people. For that reason, you can, in the right circumstances, go into court and seek an injunction compelling the defendant, that's the Affidavit of Support sponsor, to immediately comply with their financial support obligation under the Affidavit of Support. The argument is, Judge, it's not good enough for us to get a monetary judgment down the line. We need relief immediately because our client doesn't have any resources and she needs this money right now to be able to meet bill payments on a monthly basis and to put food on the table. So we need an order right now compelling the defendant to perform that obligation. That's what we had in this piece of federal litigation. We prevailed on a preliminary injunction motion, and the judge agreed that our client was being irreparably harmed by the defendant's refusal to comply with the Affidavit of Support obligation. And she said, defendant, you have to, on a monthly basis, provide that needed financial support to bring the plaintiff's income up to 125% of the poverty guideline. And he didn't do it. Radio silence from the defendant. So then what? Federal courts have the inherent legal authority, broad legal authority, to make good on the orders that they issue. And a good way to really get a federal judge mad at you is just ignore a lawful order issued by the court, which is what the sponsor did. One of the things that courts can do using their contempt authority is to imprison a party to litigation until they choose to comply with an order. And that is exactly what happened in this case. The court ordered this sponsor detained. That's a warrant that's going to be enforced by the U.S. Marshal's Office. And that defendant can go sit in federal detention until they comply with the Affidavit of Support obligation. So this, I think, is kind of the high water mark, for really taking it to the mat to make sure that sponsor makes good on their obligation. That is a serious consequence of blowing off the financial support obligation to begin with, and then number two, blowing off an order issued by a federal judge. Two big no-nos. All of this could be avoided by simply, as the sponsor, complying with that pretty, financially minimal obligation to provide support equal to 125% of the federal poverty guideline. Is this an outcome that we're going to see in a lot of cases? I wouldn't expect so. Even to have to seek an injunction is relatively unusual. I was corresponding with a defense lawyer right before I went live with this video, asking for them to not make us file a preliminary injunction motion and just agree that the defendant will provide monthly support to my client while litigation continues. Because why would you fight that out? If you're not, the affidavit of support remains in effect until one of the 5 terminating events that are listed right there in the contract. Usually there is no question that the affidavit remains in effect. If you're not arguing that the contractual obligation has terminated, then we really should not be in an argument about whether your client is going to comply with this thing while litigation continues. We can have a fight about what damages are due, but if you're not disputing that the affidavit of support remains in effect, don't make us go file an injunction motion to force your client to comply with it. Just do the right thing and voluntarily comply. So this case that I'm mentioning, I'll put the citations in the comments to the video later, but again, clear message to sponsors, take the affidavit of support seriously, and certainly if you are on the receiving end of litigation, take it seriously, most certainly once an order has issued compelling your compliance with the obligation. So one more major win for affidavit of support beneficiaries out there. If you have questions about enforcing the affidavit of support or anything relating to I-864 enforcement, feel free to jump into the comments and I'll be happy to answer them. If you are a green card holder who would like an individualized case assessment of your rights under the affidavit of support, feel free to reach out on our website. We do free video consultations via Zoom all across the United States. Hope that's helpful. Stay well, everybody, and stay out of federal penitentiaries.